talking about procurement, and you'll probably hear me refer to apples a few times tonight, but essentially what we're talking about, goods and services, contracts, your landscaper, replacing the roof and what have you. I'm sure everyone's had the experience of looking across 100 pages of responses from various vendors. And what you have often found is one's an apple, one's a pear, one's a peach, right? And so it makes the process a little more difficult. So what we like to recommend to our boards is that we really do have a plan when we talk about our various contracts. Okay, so service contracts are one side, and you can always think of the biggest ones, right, are going to be your landscape and snow removal. Some of you might have pool contracts. Some have security services, right? So that's on the service side. The other is you might be finding a roadway replacement, asphalt driveway, concrete roofs, siding, gutters, downspouts. I don't know if I missed anything, HVACs and so forth. And those are more of the the capital items, right? And what we really recommend, the actual bid itself, that's the shortest part of the whole process. Okay. The real part is really having a plan, okay? And what we really recommend is that, a plan a year in advance, you're doing a pretty good job, okay? But what we really want to stress to our boards is that you really have a plan, preferably before the budgeting season, right? And this is where you've identified what contracts are expiring and what capital improvements are we going to make next year. All right. We like to put that in what we call our 12-month plan. So I'll give you an example. If this is the last year of your landscape contract, and or actually you just finished your snow contract, let's say, then you really do need to be working on your new snow contract, at least by June. All right, because you really want to be able to plan that. And that's going to start, well, they all seem to pick months, but let's just call it October 1st or November 1st, right? So you want that really locked down, put to bed. And so you need to put that on your calendar that says, you know what, we're going to talk about that in March, maybe do some, more discussion in April, we're going out to bid in May, we're making a decision in June, right? And what we like to talk about, regardless, whether it's the landscape contract or the roof replacement, the really key is for the board and your management company to identify the scope of work. And that's really where most people run into difficulties, and that's where you get apples and pears and sometimes watermelons, okay? If we're talking about a roof, it's probably something you and your management company can do because it's a problem building. But typically, when we do roofs, we're doing them in phases. We're doing them throughout the community, and technology has changed because I'm going to guess your roof is 15 to 20 years old. We do recommend an architect, an engineer involved in those specifications. And if you've ever seen their roof specifications, they're right down to the weight of the nail and the weight of the felt and how it's going to be installed. And we want to use that same logic towards everything else you do. So, the first step is to have a plan, right? And we talked a little bit about have that plan far enough in advance so people are doing their pieces. The second piece is to understand the specifications. And I love all our vendors, and I'm sure you work well with many vendors. But if you let the vendor write the specification, okay, you're not going to you may not get what's best for the community, and you may not get it at the best price. So typically the management companies, I know our company, we know how many layers of asphalt driveway takes, right? And if our director of building services is going to know that your base in the driveway needs to be at least 6 inches of stone, C5 and C6 or something like that. And the first layer is going to be X amount of inches compacted. The second layer is going to be X amount of inches compacted. And you can write those specifications, right? And you have expertise that can do that. When we talk, and the reason why we want to do that, so if you want to think about, you want your management company or your committee who's working on this to do a little research, right? And identify all the components. So when somebody comes back to bid, they're all bidding on the same thing. And you know you're getting also what's either within code or what's an industry standard. And you're not guessing that, boy, this is a great price, but it doesn't come with an engine, right? You know, you want to make sure the engine is also in the scope. If I talk about service contracts, let's talk about landscaping, right? You know, and snow removal. Very popular today is that and we recommend it wherever possible, is that you have the same vendor doing your landscaping and snow removal. It helps a lot in dealing with the snow damage, right, and the plow damage, and you know the landscaper is responsible for fixing what he damaged when he was plowing the snow. But there's other benefits. And we recommend, by the way, when you look at that you've identified. So how many inches is the lawn supposed to be? Is it 2.5 inches? Is it 3.5 inches? But you've identified what that is. You've identified how many times you're going to apply fertilizer. We also recommend that you identify all the extras. I don't know how many folks deal with some landscape contracts that, you know, now you're going to come back and do pesticides, you're going to treat Zimmerman moths, and you know, every year you do it, but it's never in your contract, it's a separate bid. You're going to decide about mulch every year or every other year. I know we have an association that we actually looked at all of this. They were using the same vendor for both contracts, but we took an approach that said, let's offer a 24-month contract that they're just simply responsible for the grounds. That's it. If it snows in July, they're shoveling, okay? And if the grass grows, you know, in April, which didn't do this year, or it grows in March, they're mowing it. And I don't know if you've encountered, you know, 4 inches, 5 inches of grass because spring came early, and their contract didn't start, right? So there's an advantage to using one vendor. There's an advantage to giving them a 24-month contract, but make that contract all inclusive. And the only way you can do that is identify everything you would expect. I know in this particular contract, mulch is always do we want to spend the money this year, right? We made it pretty simple. Their job in that 2 years is to maintain 3.5 inches of mulch, period. So if it needs, that's it. So we don't go through these mulch decisions, and we don't go down the road of we got bare ground, and now it's time to go spend a fortune to replace it. All right, so these are all things that you can put in your contracts that you've identified, and now you've got the vendors bidding on all the same items. And you'll find that if you're interested in it, you can always contact me for some more details on that, but that's just an example of identifying specifications. In those specifications, you want to identify some very key items, okay? What are your insurance requirements? Your management company should be well versed in that. We routinely go to, you know, our association's brokers. You know, we have them look at the governing documents. We always double check to make sure that the coverage you're receiving under your policies, in fact, one, is satisfying your governing requirements, and that they're in compliance with the Condominium Act or the Common Interest Community Act or the non-for-profit. I mean, there's a little piece of it in everywhere. But you want to be upfront with the vendor on your insurance requirements, okay? A helpful thing to always include in your requests, service contracts not so much, capital contracts, there's no, oh, sorry, I have to back to you. There's really no reason to pay a deposit. And I will tell you, this has been sort of a 3-year process for us because it has been standard to pay a deposit on service work or contract work. But the truth is that the vendor has all the protection in the world, because if the association doesn't pay them, then they collect directly from the residents, okay? Unfortunately, if something happens to the vendor, you've got nowhere to go, right? So there's really no reason to pay deposits. we use what's called a preferred vendor list, and you'd want to work on that within your own association also. Our preferred vendor really means that we have 5 vendors or more in every category that has agreed to the terms of the bid process. They've agreed that they will respond to every bid, not just when they need work, okay, you know, and not when they're slow or if they have time. Every one of them has agreed to do that. Every one of them has agreed that there are no deposits. Terms are net 30. And every one of them has been vetted. They're known in the industry. They have a good track record. They have referrals. So this is a pretty ready group to go. Now, and we don't limit it to that group, but as an association, you want to know who are the 5 people that can do this job right. Because then at the end of the day, we're only just talking about price and reputation to some degree, right? That list can be certainly more than 5, but we've already identified, you know, how tall the grass is, what the compact on your asphalt, you know, what the compact rate is, how much asphalt you're doing, seal coating, all that kind of stuff. It's all been laid out for them. They're just bidding now on everything being the same, okay? And I am kind of running through this a little fast. There's a few more items in here. I just kind of skipped by identify qualified vendors, and that's really what I was just talking about. Payment terms. So you've done all this work. You said next year we're going to seal coat, or next year we're replacing driveways in phase 1, or next year we're doing the roofs, or our contracts for landscape and snow removal is expired, right? You've gone through the specification process. Everybody knows that grass is going to be 3.5 inches, and asphalt's going to be this, and concrete's going to be that, and paint's going to be, you know, a particular brand of paint. By the way, I might have left that out as an example. You should identify which paint you're going to use and not leave it up, because one vendor's going to quote Sherwin-Williams, somebody's going to quote the other product. There's several companies out there that will pick the right paint for you for the right application, and you know, then everyone's quoting the same brand of paint, right? And I left that one out before. But you've gone through all of that. Now you're ready for the easiest part. The easiest part is you've got your specifications. We do recommend, depends on the size of the management company you're working with, but we do recommend that, you know, at that point your manager's been involved with you all the way up to it. Everything's been identified. The board knows, board's agreed on specifications. What we do is we take somebody internally who then takes that documentation and delivers it to the vendors, and that becomes the point of contact. The vendors are given 2 weeks, typically 2 weeks. Some of the bigger projects take longer, but they're typically given 2 weeks to respond. Our centralized person collects all those bids. During the 2 weeks, they're answering questions. They're clarifying. Vendor has a question. Do you really mean this or really mean that? We take every question every vendor asks, and we send it back out to all the vendors with an answer. All right, so we keep everybody on the same page. Yes?
Can I ask a practical question about writing up the specifications? Because I know our board has an issue, or we've had challenges with this. I guess practically speaking, how do you get, you know, let's say if you have 5 board members, how do you get them all to agree what it is you need done? You know, because a lot of us don't know, you know, buildings, property, the terminology we use, and then communicating that to the property manager.
Yeah, it's a great question. It's really a great question, right? You know, some boards have some more expertise on it in certain areas, but the truth is that, you know, your management company's been dealing with driveways and sidewalks and all of this for years, right? They should know what works, you know, so you look internally to the management company first for their expertise, okay? And you get really the basis, particularly when you talk about asphalt and painting and wood replacement and striping and seal coating. I mean, that should just be 101 for them. And they should be able to explain to you what this does. We, like every company, we learn a little bit more, you know, every year. You know, there's a new seal coat out, that is far more environmentally friendly, dramatically more friendly and preferred, but it was like 3 times the price. And so a couple of years ago, we gave boards that option to look at, so that would be a board decision. Here's something that's really green, it's 3 times the price, and they passed. The same project came up again 3 years later, and you know what? That cost is now only about 10% more. So keep track of the technology, keep track of the changes. Some things maybe you can't afford now, and those are discussions that they should have with the board, right? And they should be able to tell you. We have a director of building services that can come in and meet with you. Your other management companies have expertise internally. He can help educate that. But it's like anything else we do. We're going out looking for people with expertise, okay? Some of the things the board would participate in is, let's talk about lawn, edging, how often, right? What's your expectation? We have boards that have taught us over the year that, that ring around the tree can't be deeper than, Jack, what is it, 4 inches or 3 inches? Yeah. Jack's taught me on rings around trees, okay? So we take advice from our other boards also, right? And they're hand dug, and things like that. So that's just the expertise that grows. So I don't know, was that a long answer to a great question? Does that help?
That's fine.
Okay, we got our quote on insurance from CAI, and the price increase
CAU,
was...
probably?
CAU,
Yeah.
good. The price increase was 31%.
Oh,
And I'm having a hard time getting an explanation for the 31%.
Great question. Not necessarily part of the bidding process, but let me get to that one. And what I'll do is actually, Michael will be up in a second. We're going to finish something about contracts, and then we're going to open up for all the questions. But that's a good question about the marketplace. I will tell you, bidding for insurance is one of the most difficult things to do. There are limited carriers who will insure your property based on your size and their exposure. And you have big names who come into the market and go out all the time. So what we recommend is dealing with a well-known broker. And that broker will have 3 or 4 lines, different carriers that they represent, and they can go out and find you the best deal. We work with about 3 different brokers. One of them who probably handles about half our properties. They even take the extra step because there's independent. CAU goes through themselves. State Farm does, Allstate does. And so we'll often get bids from those. They'll evaluate those bids versus the other bids. And sometimes CAU is less expensive than Philadelphia in a particular market, right? So that's that bidding process. Quick answer to your question. I don't know if you've had an experience ratio, any losses, but I can tell you everybody in the room is paying for Sandy. Anybody remember Sandy? Okay? So it's a funny thing about the insurance world, right? When they have a bad year, okay, great. You're going to be paying for it for the next 3 years. So we're probably into that 3rd year cycle. We've seen rates go up. Some have been gracious at 8 or 9%, which used to be unheard of, and we've seen rates go up 31%. But I would bid that out. That sounds.
Yeah, at least go get some other quotes.
Yeah,
I would not
that definitely
bid with the
sounds.
31%.
Can I interject here?
What's that?
Can I interject to her question?
Sure.
We don't, every year we do this, and CAU always comes in with the most competitive price.
Yeah.
And
So,
they-
they're a good
because-
carrier.
yeah.
Joel Davis is probably who
Yeah,
you're working
yeah,
with.
correct,
Yeah,
yeah.
yeah.
State
those-
Farm, Allstate, it's like they're double
Yeah.
CAU, so.
Yeah. So there's a couple other brokers who represent some other lines if you want some comparisons. But CAU is generally pretty good. I don't want to get way off the subject, but it's an example of also knowing the specifications. Some insurance companies have a deductible per unit on certain coverages like ice damming. Okay, so some have it per occurrence. So some things, and that's why you want somebody really looking at it. We are going to have to move move up.
Oh, I want to interject on
Faster?
that topic, just one, another thing that I
It's a
actually
great
saw.
question, I knew it was gonna get some.
It has me thinking about a couple of meetings I recently attended where we actually sat and talked to homeowners, and the homeowners were getting the wrong type of insurance, and the association wasn't insuring what their governing document said. So for years and years and years, an association has been treating it like it was an HOA, when in fact the governing documents treated it like it was a condominium association. Those are two separate types of policies, and the coverages are completely different. And it's shocking to me how many times I have educated insurance brokers and agents, when you call them and explain to them, there's a difference here. And they have a responsibility to ensure what the association actually needs and what the requirements are. So don't assume that the insurance company is quoting you the correct type of insurance. I think that once in a while, 2 times now in the last month, I've seen the wrong type of insurance being purchased by an association.
We're getting our quotes through our management company.
Okay. So that's just one other reason why it could be skewed.
And we do, it's a hard one to get multiple quotes from, but it is something that you want a little bit more digging into. And there are several out there who specialize in condominiums and homeowner associations and townhomes, and that's usually where. Allstate and State Farm is a little hit or miss. It really depends on the agent. But these other brokers are actually, that is 99% of what they do is going to be homeowner associations. So we were talking a little bit, so the request for bid has gone out. Vendors have had their opportunity to ask clarifying questions. The communication has gone back and forth between the central person and each vendor. And finally, the due date's there. Sometimes vendors are going to ask for an extension. If we're within time, we may grant that. But our goal was to have it in the board members' hands, at least a week before their next board meeting, right? Or whatever date we've agreed on with our board. Once that's all said and done, and they're all received, they are scrutinized to make sure that, when we ask for an apple, you didn't quote a pear, okay? And we'll give vendors an opportunity, because we'll just assume they made a mistake. We'll give them an opportunity to clarify. You quoted us a pear, we asked for an apple, and sometimes it's just one line somewhere. So you really want to be careful with that. So now they're all in. Now you have a stack of bids this thick. And what we really recommend is a single page. Since we've all agreed on the specifications, we should list those recapping specifications. But now you're just comparing all the vendors on one page. And now you're looking at price, and you're looking at a column of comments. They want to get the work done. Let's talk about interior painting. They want to do the interior painting in October. Okay, you may want it done by July, but at least it'll give you a choice, because if you do this one in October, you know what, they'll save you some money, right? You may want to, at that point, the board is looking at their choices, and the board's absolutely empowered to go back and say, well, let's go back and ask these other vendors, if we let them do it in October, what would their price be, all right? So you're still in charge, right? You're managing that. We do recommend, particularly on the big projects, and if you're not familiar with maybe some vendors on that list, that you invite your top 2 picks or top 3 picks in for a brief meeting. Get to know them, let them show you who they are, right? At the end of the day, the board should be able to make a pretty easy decision. We do have another recommendation, 2 more recommendations. Project management. I don't know how many of you have property managers who climb up on the roof and count the shingles. Who? Nobody, right? But you know what? They're out there. We're usually, depends on our agreement, but we're either on the property once a week or every 2 weeks or once a month, depending on our contract. But you got work going on throughout it. So you're doing driveways and asphalt and things that happen over 10-day periods. Or roof replacements, concrete, things like that. We really do recommend that you look at available resources to be your eyes on the ground. And we call that's what we call project management, right? Who's measuring the asphalt, quite frankly, okay? Asphalt has to be applied at a certain temperature. If it's not hot enough, it actually ravels when, within weeks after going down the top coat, because it actually wasn't hot enough to form. But you want people to do that. So we always recommend that you look at it. Sometimes it's an engineer who has a fee that will do that for you. We have people in our own organization who will manage it for you. I'm sure other management companies do too. But they're on site inspecting the quality of the work and making sure you get what you paid for. Last thing, and I'm going to turn it over to Michael because it is probably the most important thing. Whether it's your landscape contract, your snow removal, hopefully you put the two together, roof replacement, what have you, right? The vendor will give you their contract, okay? You want to give the vendor your contract. And the way you do that is you have your attorney review their contract. And love our vendors, but I promise you, the contract is in their favor, okay? It's just nature, right? So, other than ours, review every contract that you're presented with, right? Some boards have retainers with their firms. Use it, that's what you're paying for it. Others, may shy away from spending a few hours worth of legal fees. I can tell you that it's really the best insurance out there because they will come up, they will review that contract, and I'm going to turn that over to Michael to talk about contracts and a couple other things. So, thank you.
I'm gonna strike while the iron is hot on his last comment. One of the major issues is there's two times that I see contracts. One of the times that I see them is the time I want to see them, which is before they are signed, because the single scariest thing that when I get an email from somebody and there's a contract attached, and I scroll down to the signature page and it's already fully executed. And the person is asking me, how do I get out of this contract? Well, I can tell you the first thing I do is I look in my system to see if we reviewed it. Because I know that if I've reviewed it, there's certain things that I've done to that contract, and I can tell you exactly how you're going to get out of it, and it's going to be pleasant, and it's not going to be an ugly response that I have to give you. Unfortunately, I'd say probably 50% of the time that I look at contracts, it's for the wrong reasons. It's for the already executed contract, and that kind of forces us to talk a little bit more about, well, what is a contract? Because Paul mentioned, there's a range of different things that we contract for. I look at, sometimes I'll get a contract that looks like it was written on the back of a napkin. I mean, really, there's no terms to it. It's very, very indefinite about the scope of the work. You can tell, one of the things I do is I look to see if the contractor is even incorporated. Do they even have a presence in the Secretary of State's office in the state? And if they don't, it's kind of a sign to me that this isn't a serious contractor. It's somebody who I'm certainly going to point out to a board of directors. You might want to be a little bit leery about doing business with this person because you run a risk. As Paul mentioned, you run the risk. All the risk lies with you guys when you enter into contracts, which is why it is so important to have a legal review done of your contracts. From my perspective, there's a handful of things that I look at in a contract. I want to look at some of the major tips of the ways are, I want to look at the term. The term of the contract is important because management contracts, more times than not, your declaration is going to limit you as to how long the management contract can be. So certain types of contracts, there's something in your governing documents that might direct me as to what your contract can and cannot do. Contracts of a certain size. Your documents may very well limit what you can do as a board of directors based on the amount of money that's being expended. Termination. Single biggest problem that we ever have with a contractor is something goes wrong, they don't do the job they're supposed to do, and we want to know how can we get out of this contract. Well, as Paul just mentioned, if the contract was drafted by the contractor, I can assure you that it's not going to be an easy ride to get out. Contracts that have termination provisions, such as with cure clauses and other methods to kind of make it difficult to get out of, well, the reality is that that's going to require you to take that contractor to court to get out of the contract if you're trying to terminate it early. So from my perspective, I want to look at the term, I want to look at the termination provisions, A subset of that is, does the contract automatically roll over? I don't know if any of you have had the displeasure of ever looking at a laundry contract or a Comcast contract, which right now Comcast is in the middle of renegotiating all of their contracts, and they're dangling a carrot in front of you saying, we'll give you a compensation package where you get a per unit upfront fee for, basically signing away, your next-born child. Now that's great for associations that have financial problems, but what I see though is that 5 years down the road, a new board comes in and says, well, we would like to go with somebody else and we don't want to be exclusively tied to Comcast. Well, unfortunately, the Comcast contract is pretty ironclad and they refuse to negotiate the termination clause. So there's that, and there's the laundry contracts that will be for 10 years, and there's a 60-day window in 10 years that you could properly terminate that contract. And if you miss that 60-day window, it rolls over for another 10 years. And if during that first 10-year term, they change any of the washers and dryers out, they add another 6 years on it. Oh my God. I mean, I'm 36 years old, and I just described 26 years worth of contract. I mean, that's the majority of my life. So you guys as board members, it's a lot of perspective needs to be put into this. First of all, you guys are lay people. You're not the experts. There is no expectation that you have any education. Kudos to all of you for being here because you're doing something over and above holding down a chair at your next meeting, which frankly a lot of board members, that is the route that some board members take. So again, it's wonderful that you guys are taking the time to get educated. But what does that mean? If you're a lay person, board members rely on the advice of their experts. They rely on their managers who, well, guess what managers do? They manage. This is what they do all day long. They deal with all the different contractors. When Paul says he has preferred vendors, it's because these are people he's vetted, and his company is willing to stand behind to a certain degree and say, these are the people we think you should be doing business with. That's something that they did, over time to find out who the proper vendors are. So you rely on experts. You should be relying on advice of your attorneys. The good news for you guys, and we'll get into this further with Palm, is that if you guys as board of directors rely on your experts, rely on advice of your attorneys, that's protection for you when somebody claims breach of fiduciary duty. When somebody says, hey guys, why in the world did you enter into a 15-year contract and you submitted that, you sought an opinion from your attorney and the protection was put in there, even if I'm wrong, which by the way is why I have malpractice insurance. We all have insurance, right? That's protection for you. So board members, you guys have to rely on your experts. It's what protects you. Palm, and again, we're going to get into it, there's a whole part of that case that goes into that issue itself, is that you rely on your attorneys, rely on your experts, and then you can't breach your fiduciary duty. You have an absolute defense to that. So, other hot topics in contracts that I'm looking for. Insurance. I want to know who's insuring who. More times than not, if it's drafted by the contractor, they're doing everything in their power to not insure, to not have obligations when it comes to when something goes wrong. Indemnification. Very important to know who indemnifies who when the contractor steps off the roof and lands on his head. Those are all important things that if you read the contract as drafted, you're not protected because they are, I assure you, they are drafting that contract, as Paul said, slanted to protect themselves over and above all else. So, kind of dovetail, the legal review is a very, very important process that you guys absolutely need to follow. Also, look for hidden costs in the contract. Now, from a legal standpoint, I don't look at the numbers. That's not my job to whether or not the grass is a certain length. That might be something that management will help you with, whether or not it's meeting your specifications. I'm not looking for those, but I certainly am looking for, as Paul said, the apples and oranges. Sometimes I've recently been handed 3 elevator contracts, and somebody just flat out said, Michael, which one do you recommend? Well, I certainly don't, that's not my job to tell you which one to go with, but I can certainly give you a synopsis and say, well, this person's ripping you off compared to the other 2 people, because, again, it's apples and oranges. What services are you actually being provided in which, some companies aren't giving you what some of the other ones are. So, contracts, frankly, are one of the top 3 things that you guys as board members have to deal with, going out to bid, entering into these contracts, because guess what? A lot of your contracts are longer than your term in office. And some people in this room may not be on the board for life. Some people, enjoy being on the boards for decades and decades. But guess what? You aren't promised anything. You aren't promised your next, the next day. You're not promised tomorrow. And you're certainly not promised the next term in office. So when you bind your association to a long-term contract, you are leaving a legacy. You are leaving that for the next set of board of directors members to deal with. And this is one of the hot topics that I deal with, is when future boards say, Michael, what in the world was that board thinking? Did you even look at that contract? Because that's another opportunity for them to take pot shots at you. If you didn't have your contract reviewed and you didn't do your due diligence, well, then that opens up scrutiny on you as board members after you're gone. Yes, ma'am?
So I have a question. So if you get a contract to look at and it literally has no terms and conditions.
Sure.
So it doesn't address any of insurance, and it might address term, but
Yep.
like, let's say it's something simple. Oh, they need to install something.
Replace a canopy in the front of the building.
Yeah, and so it's little, because we get a lot of proposals / contracts,
Yep.
and there's just one page, they list what they're doing, the price,
Yeah.
or cost, and that's pretty much
There's-
it. The term, like net 30 or whatever,
Yep.
that's kind of it.
There's two things, do you want me to answer, like, what you should do with that?
Yeah,
Okay, there's two things I do with contracts. If a contract is relatively complete, I do a rider to the contract, which just means I change some of the terms I don't like, I add the terms that I want. Basically hitting the ones I just talked about. If it's a contract like you just said, I write the contract myself and I make that an exhibit to the contract. Because that has so few terms that what I want in my contract, that's not a contract anymore. That's an exhibit to a contract. That's somebody putting, a couple ideas on paper about what they're willing to pay and what they're willing to do, but that isn't telling us anything. So I have a contract form that I use that I would prepare in that instance, and that would become an exhibit to the contract. And
Would that be also like expressing a warranty?
absolutely, if there's any warranties in that document, if there's any warranties that we want to set forth, again, if you're getting a one-page document, you're not getting the protection that you need to be getting. And Paul touched on this briefly. You're in the driver's seat when you're contracting with people, because you guys hold what, right now, it's an industry where there are contractors out there looking for business, and you have the opportunity to go out to bid and have people compete for your business. You're in the driver's seat. He talked about, having down payments and having money up front. Absolutely. Why are you paying, money up front on certain services? Why are you giving in on certain issues such as termination? You don't want there to be, if you can and you have the ability to negotiate those things, why wouldn't you? Why wouldn't you ask for 60 days out for no cause when you can get that? And if you don't ask, you won't get. And that's really what it comes down to in contract. People will say that everything in life is negotiable. Well, it's even more so negotiable when you're talking about, you guys are collectively representing, sometimes in some cases, hundreds of units. And you have an obligation to try to get them the best scenario you possibly can. And arguably to not do that, to not seek advice, ask questions to your manager, not ask questions to your attorneys, you're not doing the best you can be doing for the rest of your owners. Does anybody else have any other questions? Yes, ma'am.
Today, for example, we were having a $20,000 replacement in our machines room, something was with water.
Sure.
And it turned out to be a subcontractor. And as a board member, I had no idea we were getting a subcontractor. Could you address that?
I mean, I would make it explicit that if they're going to have a subcontractor, that'd be by written authority of both parties to allow it. Or there would be no subcontractors allowed, period, under a contract. That's simply another term in an agreement that either you are or are not willing to allow a subcontractor on your property. Because guess what? That subcontractor, you don't know how that person's insured. You don't know how that person's going to perform. Because guess what? You didn't enter into a contract with that person.
It starts in the bidding and the scope too, because we have associations that absolutely no subcontracting allowed, period. And that's part of the bid specifications. We have others that, that they have to identify it, and that's where we really want the attorney to hold those people accountable to the exact same requirements, the legal requirements, the insurance requirements. In some cases, the subcontractor, is not a bad choice. It's not always a bad choice, I should say that. Often it's probably a good choice, but you need to know that up front, right? Bob?
Yeah, the contractor itself, even though he has a subcontractor, he's still liable for any damages that may occur. Is that correct?
Well, it depends on what the contract says. I mean, I certainly want to know what the contract says, because that, he can disclaim liability in his
Really?
contract for what his subcontractor does.
Again,
Certainly.
if they write it, it is. If they review it, it is.
Sure.
If you don't get it reviewed, you may be dealing with a subcontractor who's no longer in business.
And that's
Release
really,
of liens,
that's the
let's
fear.
talk about release of liens, right? I mean, those are really the things that come along. And those are things that you're gonna look for, particularly in these projects, is what assurances have you been given as a board before you cut that check, that their vendors have been paid? So that subcontractor, if he doesn't get paid, he can come back and charge you again, okay, and place a lien on that equipment, right?
Yes,
We'll
a
talk
very,
liens.
very important provision, especially when you're talking about larger contracts that are phased, where there's different components in the contract. You absolutely want to make sure that as time goes on and as things are being done, that because you're going to be, you run the risk, if something were to happen, as Paul just said, that somebody who's supplying materials to the contractor and the contractor goes belly up, that person is going to look to the association. So a lot of times you're getting releases of liens periodically throughout the contract life. And that's very common in large-scale projects where we see multi-million-dollar projects where periodically you're looking for them to release any liens that might be out there. Thank you.
How about situations where the contractor wants like a third of the bid price up front in order to buy material?
You know what, that's relatively common, and I don't have a problem with it if the number actually makes sense to what the materials will cost. I just have a problem when I see it's a much more inflated number than that, and they're looking for half, and the materials are only gonna cost, a third or less, a quarter of the project. I get it, I understand that somebody may need that, the money to procure the materials. But if it's out to bid and there's a number of different people bidding on that, that's certainly a factor, right? I mean, if somebody's willing to do this without having to take the 1/3 up front, that might be a factor for an association.
Risk is the issue here, really it is, and that's why we don't recommend deposits. You want, first of all, you want, there are, and I shouldn't say, we don't recommend deposits, but let's talk about like a roof project, and you're gonna spend $600,000, right? You can pay them in phases, and that's
Right.
very acceptable, right? But the goods and services are provided, you get your release of lien, and you pay them that first $200,000 because they did $200,000. So, because in those kind of projects, you don't want them, we can understand they don't want to put out $400,000 in labor and material before they get paid. The other 200 is their profit, right? But we really don't recommend the third. And if it is, things that, the onus that we want to have to put back on the board or recommend to the board is what happens if the owner unfortunately passed away today? Okay, where's that money? Who has it? Because in many of these cases, and that's why we look at the vendors, and we've mentioned preferred vendors. I do want to stress that they're not the only vendors, okay, that we send bids to, because we collectively get additional vendors from our boards. But what I really want to stress is that we look at the vendors that we know that they have the cash flow to fund the project. And we get a little concerned when they need the cash to buy the material, right? So that means their next job is always paying for the job that just got completed. We're just a little leery of that. And back to, I think Michael supported it before too, is that you're taking all the risk, they have none. I know it's a question.
You mentioned twice or 3 times release of lien. When is that acquired?
It depends on the contract, because you can actually require in a phased contract that periodically, when X amount of the project is completed, that there be a release.
You said
Issue.
phased contract.
Correct.
But you can't get it up before it's done.
Correct. I mean, it'd be unheard of for them to release before actually.
During the process or at the end of the process,
Correct.
you can ask for a release of lien.
Correct. And normally that's something, in my standard contract, that's something that's in there, is that they're required to provide that.
Before you give them $1, whenever you're giving them that $1.04, you want to know that the association has no exposure to having to pay somebody else that dollar.
Yeah, in the perfect world, you'd get a release every time you made a payment, right?
Yeah.
So that would be the perfect world answer.
Yeah, now on smaller projects and $2,000 projects and $1,500 this, you know, maybe fewer hoops to jump through, I will admit, okay? But that's usually not what we're talking about, right? We're talking about the, you know, we got an $89,000 asphalt replacement project going on. We had a $20,000 seal coating project going on. We want, those are big dollars. Not that 1,500 isn't big dollars either in this market, but yes.
Is anybody else, sir?
Yeah, could you talk about waiver of subrogation as concerns liability?
Sure. Well, the big picture answer to the waiver of subrogation, there's actually a provision in almost every condo declaration, almost every declaration I've ever seen, and the Condo Act has a waiver of subrogation. Now, the waiver of subrogation provision in those documents is as it relates to damages from one unit to the other, which is a whole separate seminar, by the way. So the example would be water runs from upstairs guy through the floor to downstairs guy. Well, there is a waiver of subrogation provision in the condo docs and in your governing docs that says that insurance company from one unit owner cannot sue the association or the insurance company to recover what they had to pay out. So that's what the waiver of subrogation provision. I don't know if there's another one that you're referring to as it relates
This
to
would
contracts.
be pertaining to a contractor, and is it typically regarding workers' compensation, so that they can't subrogate back against our insurance company? if
Yeah, I don't know
we're-
why you would want to have a waiver of subrogation provision in a contract, because you want the ability, or you want your insurance company to have the ability to go back and get money from another party's insurance company.
Yeah, I think what Michael's
We're talking about two different things.
You're probably, yeah, Michael's referring to them coming against you.
That's what I'm
It's
talking
rare
about.
that you're, yeah, but the truth
I have
is,
a contract, his example.
you want to go against them.
No, I don't. I want to be sure that they don't come back against me. I have a roofer, he falls off the roof.
Sure.
His workers' compensation, does he come back against me?
Well, it depends, the contract needs to talk about who insures that type of injury. Because you're gonna, that's one of the major topics about contract review is insurance. Who's insuring who, who's insuring the employees on the work site? And that makes a big difference. If it's the person, if it's the contractor who drafted it, I can assure you, you're gonna be your insurance that is gonna be picking up. If I reviewed it, I can assure you that it'd be the other way around. They would have to have insurance for injuries on the work site.
Yeah, and that's where go back to the original specifications. You want to identify their insurance requirements, and before the work begins, you want to know that you've received the certificate of insurance, and not only are you named as additional insured, you want to also know that your management company is named as additional insured, and you want to make sure that you're the policy holder. And what happens is if they don't pay their bill next month, you're going to receive notification that their insurance is canceled. At least you're going to get a heads up. But you need to have those on your insurance, and those are things that, you know, again, people will look at, they'll be recommended. That's why we always involve your brokers in your insurance coverage.
Yes, ma'am.
The association has decided that they pick a person to do cleaning the vents out from the dryers. They recommended this person. Now people from the association are calling the management company. They're taking their names and then giving it to this fella who's getting paid $25 per unit.
So
Now,
whose responsibility is it?
that's.
I mean, that's the question. If you're giving a recommendation because you guys were able to negotiate a bulk rate to get all of them done, and then the owners are paying?
They're paying directly to this person. He's not even an employee or anything.
Okay, so the question would be, though, is if it is an owner's obligation to clean out the dryer vents, because that's a very common area, we have to look at the documents to see who's responsible. It matters which type of association you are, if you're townhomes, if you're.
But I'm saying that the managing agent, they're taking the information from the owner. The owner's calling the managing agent and saying, okay, Joe Schmo's gonna come and fix that for you. Joe Schmo goes and gets the $25. The association's not getting any money. If that man gets hurt or does some damage, is the association responsible?
So my argument would be that the contract's actually between the owner and the contractor. It's not, the association obviously lined this guy up, brought him on and maybe negotiated a good rate, $25, where maybe it would be a $50 job. But that's a transaction between the owner and the contractor. I mean, that
So
would
if he
certainly
gets
be the
hurt, you
position
don't
I would
have to
take.
worry about workman's compensation?
Well, let me add to that one. When we go back to your bid specifications and why you want brokers, people who are experienced looking at this, and we had this conversation with several of our boards. You have no employee, let's use that scenario, there's no employee, right? But you'll find that your management companies do, or should be, recommending that you carry workers' compensation coverage. And we have that discussion often. I have no employees. You want to protect yourselves, and the biggest thing that this particular coverage does, and it's usually just, you know, the basic coverage, is that you've basically hired an attorney with that coverage to defend any claim against you for workers' comp. In the event that they're not successful, they're also going to cover it, okay? But 99% of the time, if we've all done what we're supposed to be doing, that individual does not have a claim against the association.
Yeah, the mere fact that you don't have any employees is relevant only so far, because it doesn't stop somebody from, as Paul said, it doesn't stop somebody from suing you and claiming that a contractor was your employee. And now you're tied up in court, and now you're dealing with battling that, you know, that whole battle. So you saying I don't have any employees really only gets you so far, and then the other side can still claim that it's employee and file a lawsuit. Anybody else have any other questions on the contract issues, procurement?
Is contract review usually an additional charge even if somebody has a contract, monthly
Retained.
contract with KSN?
No, that's a great question. So, one of the contracts people have with my firm
What was
is,
the question?
is contract review a separate charge, generally speaking, for legal? I can answer that two ways, and we're gonna make this the last question because we gotta take a break before we get off into our whole discussion about Palm. Two answers to that question. One, generally speaking, most law firms would charge you hourly to review your contracts. My law firm, because we represent over 4,000 associations, and we've heard it all, we've seen it all, we've done it all, is that we have retainer programs that we offer that's a flat monthly rate, and contract review is part of 2 of the 3 retainer options. So the answer is yes, it would be covered. One of the major things, I probably review 3 or 4 contracts, different types of contracts a day. So for better or worse, I look at contracts in my sleep kind of. So yes, and if anybody in here is not either a client of KSN or wants to discuss services or retainer programs, just see me when we're done. Okay, and with that, we're going to take a break for probably about 10 minutes, and then we're going to delve into the wonderful world of Palm. And then you can save your questions. I really don't want to be here all night if I have to be here all night. My kids will be asleep either way, so it's really not the end of the world. The funny thing is that this case has kind of taken on such a life of its own that my parents live in Wisconsin, and my dad even asked me about it. He's watching my kids right now because my wife's out of town, and he asked me a question about the Palm case. And I said, how in the world are you hearing these things? I said, it's funny you asked that because I'm actually going to speak about, not supposed to be about Palm, right? But I knew I'd be talking about it anyway. About 85% of the time that I spent for the last 3.5 weeks has been on conference calls, talking to management companies. Management companies are great to talk to because I can kind of hopefully eliminate going to every single board of directors and having to have the same talk, because I swear my wife's going to kill me in my sleep because I'm sure I'm talking about this case. I have to be talking about it because that's really consumed our lives. Now, it's been a good thing because it's given me a chance to get in front of board members to talk, but I really don't like the topic because there are certain parts of it that A, I disagree with, and B, I know it's making your lives a living hell. So, I want to do a couple of things. I want to give you a little bit of a history about the litigants. You know, why are we here? What happened that got us where we are right now? And some of the peripheral facts that make it very interesting. And then I'm going to give you a small history lesson on the statute, and then we'll get into all of the crazy things that happened in Palm. Gary Palm. Gary Palm is somewhat infamous now. He is a retired law professor. He was a law professor at Loyola. He is still very active in the legal community. My understanding is, ironically enough, I got an email yesterday morning that they have set up a committee to talk about drafting legislation around what happened in the case. And guess who's on that committee? Gary Palm. I almost fell out of my chair. So that tells you that Gary Palm didn't anticipate how far to one side that the court was going to go. So Gary Palm is, as I said, he's a retired law professor. Some people in here might go to sporting events for entertainment. Some people might do some gardening for entertainment. Well, Gary Palm litigates for entertainment. He obviously gets a charge out of being in court, and he gets a charge out of seeing his name. And you know, I look at him as a perfect storm person to mess with. You know, who can we poke? Who can we, give a hard time to? Don't poke Gary Palm. That would be, and really, there probably is only one or two Gary Palms in the state of Illinois. There really aren't that many people that had the tenacity, that had the ease to go into court and represent himself. Because remember, as a law professor, he was an attorney, so he's licensed. So he didn't have to pay anybody to represent him. Anybody else in the community who filed this lawsuit would have spent hundreds of thousands of dollars. The number is so high because this lawsuit, the underlying facts in the case, happened in 1992. In 1992, I think I was in 7th or 8th grade. So I rack my brain and think to myself, and what was I doing in 1992? And this is now this lawsuit that I'm talking about in front of you guys right now. So perfect storm scenario. Gary Palm had easy access to the courts. He liked to mess with people. Guess what else was going on? There's a board of directors that wasn't doing what they should be doing. They were holding meetings very, very infrequently. They weren't giving proper notice to the meetings when they had them. And we'll get into that as one of the things that the court weighed in on. They were showing up to their meetings, and what they would do is they would say, well, we're going to ratify what we did for the last 3 months. Boom, gavel down, we're done. And some people might be shocked to hear that, but I can tell you that of the hundreds of associations that I deal with, not to that extreme, but it's happening. And I don't want nobody needs to raise their hand or call themselves out, but that became very commonplace in the industry as time went on, that it became much easier than to have meetings and to transact all this business and darn it, there's a Blackhawks game tonight and we don't want to be there all night, so we're going to transact business outside of the meetings. And over the years, I think even the lawyers and the managers and everybody started looking the other way. And we started finding ways to say, you know what, that's okay, just ratify it at the next meeting. Well, the Palm Court obviously said that's not the case. Let's talk a little bit about who this affects, because I think that's important, because I get a lot of the questions asked of me is, well, I'm an HOA and I'm in Rockford. That doesn't affect us, right? We don't have to do anything in this case. It doesn't matter. I'm not a condo, and I'm not downtown Chicago. I'm not a high-rise. Well, the answer is this. When the case first came out last month, it was considered a Rule 23 opinion. A Rule 23, it's Illinois Supreme Court Rule 23, says that it's only binding on the parties to that lawsuit, so it's a limited opinion. An appellate court has the right to issue two types of opinions, a full published opinion or a Rule 23 opinion. When it first came out, we all speculated in the industry, why was it a Rule 23? Thank God it's a Rule 23, because otherwise I'm going to have to stand in front of these meetings all the time and talk about it. But then Gary Palm, in his infinite desire to see his name, filed a petition and asked for the court to publish the opinion. And the Illinois Appellate Court very quickly agreed to do so. And on May 2nd, so earlier this month, it became a published opinion in Illinois. It is binding authority if you are a condominium association in Cook County, which is the 1st District. It's the 1st District Appellate Court. It scrutinizes the Condo Act, it's very clearly going through the Condo Act. If you're a condominium in the 1st District, these appellate justices are looking right at you. If you are an HOA, if you are not in the 1st District, if you're some other form of entity, it's persuasive authority. Once a case gets published, it now can be used as persuasive authority. So if there is a lawsuit in Winnebago County, out in Rockford, and it's an HOA, and a unit owner or a member decides to sue the association because they're not following formalities, they can cite the Palm case. And that court, and that judge in the trial court level can choose to either follow or not follow. It's important because there's one major provision that really causes most of the strife in the Condo Act, which is, it's the definition essentially of conducting business. Conducting business appears in the meeting section in the Condo Act, where it talks about meetings and board meetings. And the term is conducting business. And the whole industry, all the managers, all the attorneys, we all believe that conducting business meant the actual votes. When you're going to make a decision, you got to make that decision in front of the owners. You have an obligation to actually conduct your vote. That was always the law, and that was the advice that the industry gave board members. Well, the appellate court in the Palm case took the position that that's not what it means. Not only does it mean the votes, it also means the discussion. Well, holy you know what, right? Because there's all kinds of discussion going on. You guys are probably, the people on a computer should probably emailing another board member right now. Hey, here's some board business, let's talk about it. That right there was head on what Paul was talking about. Now, that really gives me an opportunity to give a history lesson. The Illinois Condominium Property Act was first enacted in 1963. So 50-some years ago, 51 years ago. 51 years ago, guess what there wasn't? Email, BlackBerries, technology. Nobody had the sophistication, Starbucks. I'm not sure what you did back then. I wouldn't be able to live. I'd probably sleep better though. So there wasn't this level of sophistication. And we all know that there's been changes to the Condo Act, otherwise we wouldn't keep putting out these new books, because there's constantly changes with legislation, but nothing has been changed directly impacting the way meetings are held and the way that the legislature originally intended for business to be transacted in an association. So when the Condo Act in 1963, when that was first enacted, you have to try to put I know it's difficult to do, but try to think about what associations, how they were governed. What was it that they were doing to conduct business? And what was the medium for them to talk about this? Well, they certainly weren't using email. They certainly weren't on their iPhone, and they weren't text messaging each other. There was never a contemplation of the level of sophistication that you guys and your not-for-profit corporations were going to take on. Whoever in 1963 could have believed that these not-for-profit, essentially just a gathering of people and trying to make it easier for people to live together and to share costs and to share rights and duties and obligations. And we're going to put together a contract, and we're going to call it a declaration, and we're going to put on some bylaws, and we're going to let them have some rules and regulations. Nobody contemplated that it was going to become this sophisticated. Nobody contemplated that that so much scrutiny was going to be put on the contracts, on the contractors, on management. You try to put yourself in the shoes of what was going on back then. It really was an unsophisticated process where managers managed. You hired a professional management company, and that's what they did for a living, and that's what their expertise was. And you hired an attorney if you had legal problems, and you had issues that needed an attorney. And you guys would show up whenever meetings were necessary, and you would talk about what issues were going on, and you would vote on those issues in front of the owners, and the owners could, if they had nothing better to do, could come and watch you do it. That's really what was going on in 1963. Nobody thought that this was going to happen the way it did. And part of me doesn't necessarily blame the appellate court for taking the position they did, because that was the original intent, was to allow the members, all of the people you guys represent, your constituents, right? These are people who, you're all little politicians, right? You guys, some people lobby to get on the board, and you guys are little miniature governments. Whether you want to believe it or not, you are. You got your own constitution, your declaration. And really, you answer to your members. And your members, under the Condo Act, or whatever statute you're governed by, gives them the right to watch you transact business and to have a level of transparency, to see how everything is being done, and to watch you discuss the different, are we going to replace the carpet in the first floor? And why are we going to do it this year and not next year? Those are the types of discussions that they believe that the owners, when I say they, the legislature, and clearly the Palm Court, believes that they have the right to see. Now, interestingly, the Condo Act doesn't give the owners the right, I know it's happening all the time, doesn't give them the right to interject, interfere, say anything in a board meeting. In the Common Interest Community Association Act, there actually is a provision that gives them the right to an owner forum. You have to set aside a certain amount of time in that statute. Well, guess what? In the Condo Act, there is no provision for that. In an ideal world, I attended a meeting with these two ladies on the board here, and I'd like to put up a big sheet of glass and maybe put a speaker in there, a microphone and a speaker, and almost like you're in a zoo, I'd let the people in the zoo out in the other part of the room listen but not be heard from. Because how in God's name are you going to conduct any business with all of the interruptions, right? And actually have a discussion and something meaningful. So, the reason why the holding in Palm, you're never going to hear a lawyer, and I hope to God you never hear a manager say, well, don't worry about Palm. It doesn't affect you. Just look the other way, or you're an HOA, it's not affecting you. The reason why that's important to me and why you won't get me to say that, at least not being recorded or an email, call me and make sure we're not on not being taped, is the definition of conducting business and meeting is identical in the Common Interest Community Association Act. So it's not going to be a big leap for the courts to say, let's follow Palm, because we have the same definition in our statute. And by the way, the Common Interest Community Association Act, every year there's legislation to make more and more of you, if you're an HOA and you don't qualify for that, so you're governed by the General Not-for-Profit Corporation Act. And I don't know if anybody that applies to anybody in here, but guess what? You're all eventually going to be under the Common Interest Community Association Act because they're making it more and more expansive. So the answer is follow Palm. Now, I have ways for you in the legal industry. I mean, we wouldn't be lawyers if we didn't have ways to get around things, right? There are ways to deal with each and everything that comes out of Palm. There are. There's one major thing that everything else in Palm, besides the one thing I'm going to share with you, and it's a lot of discussion, is what the law was before. Follow your governing documents. Follow the Condo Act. As I already said, people were just getting away from, it's almost like the grapevine where you listen and it changes over time what you heard. People were just making, because of technology, they were cutting corners. And it was easier to send emails to everybody. Why would I have to mail these things, or why would I have to do that if I could just send a quick email and we'll just do a quick vote and we'll know what the result's going to be. Yes?
Just out of curiosity,
Sure.
since I know how many people are here, is there any board represented as a quorum tonight?
Yeah.
So we have a quorum.
Sure.
That's
So if you
good.
could separate,
No, here. I'll explain why this matters. You don't have to separate, but I can tell you shouldn't be talking about your association's business to each other. And you certainly forever will have to answer to it. If you had a member of your association sitting here, and that's a funny question because you know how many times I've now gone into associations and talked to their boards and violated Palm? I'd be sitting there and all of a sudden I think to myself, wait a minute, how many board members are here? Yeah, we're violating Palm right now. So let's try to keep it, let's not talk about association business as much as we can, because that's really the impactful thing that came out of Palm was, again, everything but the one topic is all what the law was. And we'll go through those different things and it's an about face. Palm case in a nutshell is a little bit of a slap in the face to the industry. It's a shaking of saying, okay, come back to life, come back to the real world, everybody. We got to follow these things. And by the way, we're going to throw you a monkey wrench with the one issue too. That particular issue is, as I already touched on, is the conducting business definition. And that definition now, under the Palm case, under the Palm Court, is expanded to include discussions. And that obviously is problematic, as I already said. That can be discussed either by email, by telephone conference, in person. If the three of you decide to ride the elevator together in your building and you decide, and somebody says, hey, how about that landscaper? Arguably, under Palm, if the fourth person in the elevator is a member and they got it in for you, you're arguably violating Palm. Before I get too far down the road, the other important thing about Palm is what actually came out of Palm. Did anybody get any big money or anything? So the answer is no. Gary Palm got $0.00. That tells you what his goal was, right? I mean, obviously he wanted to make law, and that's important to note because if and when, and I say if and when because most likely nobody in here is going to 100% be able to follow Palm over the next 6 months. I want you to. I think Paul wants you to. But the reality is, it's utopian to think that it's 100% followable. And there's a number of reasons, one being emergencies. I mean, okay, the pipe bursts. Well, the Palm case didn't address, I find it somewhat irresponsible of the court to not address a major thing like an emergency situation when they tell you have to call meetings. Well, how can I call a meeting if water's pouring in through the roof of my building right now? Do I have to wait 48 hours to say, that poor person who's, getting rained on? Well, I gotta wait 48 hours, sorry guy, I wish I could help you. No, that's not the reality of the world. So there are things that it's gonna be impossible if you were to do exactly what I'm telling you to do, there's difficulties with that. But I have an obligation to tell you nonetheless. So, emails, phone calls, anytime you have a quorum of your board, and for example purposes, the easiest thing is just to say it's a 5-person board. A quorum of your board is a majority of your board. So if you have 3 people present in person or by technology, meaning by if a person is by Skype, by FaceTime, if those people are all together, it's considered that you're holding a meeting. Excuse me. And under Palm, that would require that you had provided at least 48 hours notice that you guys were going to get together and talk about association business. Well, they went on to expand that and say that email canvassing, which is essentially holding meetings by email, where Paul sends out three proposals, or he sends out, hey board, what do you think of this? And board member A hits reply all. You've now just conducted a meeting under Palm. Because by the time you hit reply all, you've now solicited information and you're discussing board business with at least a quorum of the board. Well, from my standpoint, from Paul's standpoint, I can tell you that the term reply all kind of needs to fall out of your vocabulary. Because that's where you're going to run into problems. And frankly, the claim that's going to be brought against you if you are ever challenged based on Palm, it's going to be a breach of fiduciary duty claim, right? They're going to say that you had a fiduciary duty to do X, Y, and Z, and you didn't do that because you held a meeting contrary to either Palm or what your documents say. Well, that's going to mean that many of your emails are discoverable. So it's not going to be a big stretch for them to find out what it was that you did or didn't do, and if you violated. Your emails aren't state secret. It's not like you're going to be able to protect them. So I know we send emails fast and loose, and I send silly emails to my coworkers and make fun of people. Well, that's all public fodder, really. I mean, that all can be subpoenaed, can be requested in discovery in a lawsuit. So I think we've kind of got desensitized to what we send by email and the silly little things we say and do, and hey, where are you going to lunch and this and that. That's all. If you think you have some level of privacy, especially if you're sending it from a corporate email account, you have no level of privacy with those emails. So you have to be very careful now in light of Palm and how you deal with your conversing with each other. We really feel in the industry what they're doing is they're pushing us more and more towards what municipalities follow, and that's the Open Meetings Act. If you've ever sat in a meeting, which unfortunately I've been in a number, where somebody stands up and says, you're violating the Open Meetings Act, this and that. Well, no, because the Open Meetings Act only applies to public entities, such as municipalities. It doesn't apply to associations, private condos, homeowners. So no, I'm not violating it. But what the court has now told us, they're kind of pushing us in that direction. They're saying, you really are kind of like a municipality, and they're kind of treating us that way. And in response, one of the things that we did is we went out and talked to some public officials. We went and talked to some attorneys that represent municipalities. And we said, well, how do you get around that, the whole email thing? And the response was, well, we BCC everybody. We're going to send out, if I'm Paul, and I'm going to send out bids, or I'm going to solicit some response, I don't send it to everybody on the to field, I hit it on BCC. And that person can only respond back to me then, because they don't see everybody else. So they don't have the right to hit reply all. They don't have the right to violate Palm. So in their case, violate the Open Meetings Act. So that's a little, an option that associations have. If they just can't stop emailing, if you guys just get the email itch at 3 in the morning, like sometimes I do, you got to be careful about the way in which you transact, because it's all discoverable in court. And again, what's going to happen to you when you violate Palm is not this multi-million-dollar, oh my God, the association's going down. It's going to be the fact that you're going to have to defend it. You're going to have to take the time. Now, it won't be 12 years like in the Palm case, hopefully, but it could be years in court dealing with discovery and digging through your emails, and the cost to the association, and the cost to your insurance company, and your insurance policy is going through the roof. So those are the types of things that you want to avoid, which is why I would always say follow Palm as best as you possibly can. You have a question, sir?
Michael, we're HOA, as you know, and so underneath the General Not-for-Profit Corporation Act, previously, if you had unanimous consent by email, you could then ratify because it was unanimous.
Sure.
Are
You
we
have
saying
over
that?
you have over $100,000 budget, all right? Okay, so you're governed by the Common Interest Community Association
I
Act.
see that.
Okay, so, great point, because again, when I said that it was kind of, I didn't use the word reckless, but I'll use it now. It was irresponsible of the appellate court to not address emergencies. And you know, we as lawyers for a long time were asked that question. Well, we won't be able to call a board on a meeting on 48 hours notice. Well, you're right, there is a provision in the General Not-for-Profit Corporation Act that says boards can informally conduct business outside of meetings as long as it's unanimous. So all five, if it's a 5-person board, all 5 board members vote and it's in writing. So email, by mail, by whatever it is, there is that provision. And really, you know what my take on that is? First and foremost, the Condo Act very explicitly trumps that. Okay? I think the Condo Act makes very clear, it overrides it, it says that all decisions of a board must be made in an open meeting. So, what you found though is a really good fallback when you have an emergency situation and you don't use one of the other things I'm going to tell you in a little while about how to get around those things. I would more than happily stand in front of a judge and say, Judge, we had no option whatsoever. But you know what we did, Judge? We did the next best thing. We went and we used another statute that applies to us because the General Not-for-Profit Corporation Act applies to all of you. So if the Condo Act or the Common Interest Community Association Act doesn't address an issue, the next place I look is the General Not-for-Profit Corporation Act. It's kind of a gap filler. And that statute's also in your books, so you have all the statutes you ever would hope to read, I guess. Sure, go ahead, I'm sorry.
You're talking about emailing.
Yep.
What about just getting together and discussing and interviewing contractors for landscaping and so on?
Okay, you touched on 2 things. You said something with the contractor thing that's going to add to my answer.
Okay.
The first answer is, the second you get 3 of your people together, if you have a 5-person board, and you're discussing association business, you are violating Paul. No questions asked.
This is insane.
But, let me try to quell your, you're on the first floor, so you're not going to be able to jump very high. Here's the caveat to that. And again, there are ways around these things. I'm going to get to them. I'm just building up to the big so, don't jump off the ledge yet. Hold on one second. So to answer her question, there are 3 categories that were in the Condo Act and that were in the Common Interest Community Association Act. They were in there before, they're in there now. There are 3 types of categories that are executive session material. And I think we probably all are aware that, and I'll go through the 3, but those are things that you don't discuss in front of the owners. You don't do that in open session, but you do vote on those things in open session. There never was a time, even though we probably all didn't follow it, but there never was a time that those 3 topics, yet you voted outside of a meeting. You discuss these topics that I'm going to bring up in a second in executive session, then you come back into open session and you vote on them. That's the way that the statutes read, that's the way that it was intended to be done. Those 3 topics are litigation, pending or imminent litigation. You want to sue that landscaper, he's doing a crummy job. If you're going to talk about it, what are your strategies, what do you want to do? We already sued him, so we're going to talk about how we want to go after the guy. Those discussions are executive session materials. The votes that are on that litigation, though, need to be done in open session. You come back in open session, you say, we vote to sue landscaper A. And the idea is, kind of digressing a little bit, is, what are the purpose of this? Why do we do this in an open meeting? Well, we have meeting minutes in open meetings, right? In the open portion of a meeting, there's meeting minutes. In your executive session, if you're taking minutes, stop, please, because you're creating evidence. And what happens in an executive session, usually it's discussion, right? You're discussing. You don't want the people to know if there's a lawsuit. I don't want to turn over my meeting minutes to the other side that said the guy's a bum, or I think he's an alcoholic, or the things that come out of those discussions in executive session. That is not intended, executive session is not intended to be discoverable, but the second you put pen to paper, you've now made it that. You're creating evidence in a trial that hasn't happened yet.
But then you're saying you're gonna go into the open meeting and vote on it, well, what do you say? I vote on and I can't tell you what.
No, whatever the topic was, depends what the topic was. So the topic was to fire the landscaper.
Yeah,
Yes,
what
you're gonna
is
say
it?
that the board discussed in executive session, whether or not they wanted to pursue litigation against the landscaper. One of the board members says, I move to pursue litigation against the landscaper. You hold a normal vote like you always would. Because here's the deal, meeting minutes are so important for your association because they are the roadmap to what you've done in the past. And I can't tell you how many times, for the first 5 years I was with my firm, I litigated. And I can't tell you how many times judges would look at me and say, counsel, will you please show me the meeting minutes where the board approved that action to sue this person? And I stand there and I stutter and I stumble and I go, Judge, I don't have the meeting minutes. And the judge immediately is going to slam me because I can't show him. We only can conduct business, right? We only do what the majority of the board wants us to do in an open meeting where their votes are done. Well, if you are doing things contrary to that, you're not following your governing documents, you're not following the statutes. So your meeting minutes, guess what? The Condo Act says that somebody in your association can request the meeting minutes from the past 7 years. You better be able to show a roadmap of the decisions you made. And if you haven't, it's not the end of the world, everybody. Don't go jumping off ledges. But that's what you should strive for because that's what the purpose of your meeting minutes are. Not editorials on somebody in the back of the room asked a certain question. I don't care. Nobody in the meeting minutes 7 years from now cares. What they care about is what were the items of action, what was the vote, who voted what way. That's all that anybody cares about in your meeting minutes. They should be simple, very clear, concise. This is what we voted on. These were the pieces of business. That's the purpose of the meeting minutes, and it's a roadmap for everything you've done through the years. Because you're going to be gone in a certain number of years and not on the board. You're not even living there. You could be somewhere else. You could be in Florida sipping on Mai Tais. You may very well have nothing to do with it. The new people need to know what business was transacted. So that's why the meeting minutes are so important. It's why it's so important you come back into open session and actually tell the world in the meeting minutes what it is you're doing.
Well, what if you're taking up some employee, or I shouldn't say employee, but, kind of like a personal matter? I thought this was the secret part that you don't want everybody in the audience to know.
I'll get to that.
Then you're gonna come out and tell them?
The second category is violations. And this is right along what you're saying.
Right.
Okay. Second category about executive session is, good segue for the next category. Violations. And a subsection of violations is non-payment of assessments. Because non-payment of assessments is a violation. You have an obligation to do that under your governing documents. Well, again, the discussion. You have rules and regulations. You want to discuss if somebody's dog's too fat or their door's too red. That's executive session discussion. Is the guy's dog too fat? Should we, what do you want to do? Is it true? Well, if the determination is through discussion that we think the guy's dog's too fat, you then vote on whether or not you're going to pursue that in an open meeting. So I know you're saying the privacy issue, you have an obligation to vote on. So if it's addressed and there is a violation and the board is choosing to send that person to, whether it be we want to send him a threatening letter or we want to or we want to sue the person, you have an obligation. If you don't do that, the ramification is, I want to be that guy's lawyer, by the way, because I'm going to go into court and I'm going to say, show the meeting minutes where they ever approved, the board approved us, the board, or the association suing you. Because you're not going to be able to prove it otherwise. You're not going to have the meeting minutes that demonstrate that that took place in an open meeting. I know nobody wants to do the unpopular thing and say, address so-and-so is going to be issued a fine of $50.
Well, then why go into the executive session? Why not just bring it up?
To
I mean, I know
discuss
it's-
whether or not you guys are actually going to pursue it.
Yeah.
Yeah, that's why you go in executive session.
But
To
what I'm
determine
saying
whether
is
or
that
not.
if you're gonna have to come back and say, this is what we decided to do, you're telling
You're gonna vote on
everybody.
what you
Yeah,
decided.
but I mean, you're telling everybody in the audience what.
Nobody's in the audience. When you go into executive session,
I know that,
everybody
you're
leaves.
out, but
And
then
so
you
now
have to
when you
come
exit
back.
executive session, nobody's there.
And I'm not asking for details when you come back in open session and you vote on something, you're voting on a specific decision. Do we sue him, do we not sue him? Do we fine him for this violation or do we not fine him? That's the vote.
In that executive session, you need to be free to say what you're.
Right,
Right,
and I
and you're,
understand
and it's the discussion itself.
But then, does that mean that all the people, well, I know all the people in the audience are gone because you're in executive session. Can't they come back in?
Yes, absolutely. So here's the classic format, because, here's the classic format is that you have an open session, you recess to executive session, and then you reopen the open session to actually vote on the items of business. I agree with you that, first of all, you guys have to live with each other, so I know what you're saying is unpopular, right? You don't want to have to call out your neighbor.
Yeah.
But guess what? I didn't write the law, and I certainly didn't, Paul is certainly telling us otherwise. So Yes, sir.
Why do you even have to have a unit number? Just say it's a resident you're going after and let it go at that.
As long as you feel comfortable that your meeting minutes demonstrate who it is that you're going after, I'm not gonna try to steer you a certain way next, we could talk about that all night. You guys have to decide whether or not that what you say and how you vote on it clearly demonstrates and indicates who it is you're going after, who it is you're gonna pursue. Otherwise, what's good is it if you're just kind of cryptically saying, we're gonna sue the guy we talked about. How is anybody gonna know who you were talking about? I mean, Brad, meeting minutes are the roadmap. You have to be able to show why it is you took the actions you took. So there has to be those votes. I'm just telling you what I agree it's unpopular. I'm not trying to win a popularity contest here. Yes.
So it's kind of like you're saying, you're voting to a $200 fine against a person, and do you name the cause? Yes.
If there's a violation of, if you want to be perfect, say violation of the dog weight policy, the dog weight rule.
Okay.
We're issuing a fine of $200. Yes.
Collections.
Great
They're
topic.
behind, they're 3 months behind an assessment. You're gonna sit there and say, unit.
Great topic. And one of the end runs around this is, okay, does anybody else have another question? Because I want to go ahead. Well, I don't want to go off too far of topic here. But
It was just, I went to a CAA forum on Tuesday, and the attorney there had suggested coding, maybe their account number or whatever, that would help so you're not exploiting that person.
That's perfectly fine. If you want to code and have somebody, this unit is actually a B, and another person C and D, I don't care. You just need to be able to explain to a judge how it is that you did what you did. If secretness is that important to you, God bless you. Just come up with some way to do it. So,
Hey, Michael, and this might help get us back to Palm, and I hope that.
No, this is, we're
you
still
and I
kind of
haven't-
on
And you and I haven't spoken about it, but it's interesting when you bring up assessment and the sign return. Maybe it's a discussion to turn somebody over to collections, right? What we really recommend is that you already have a collection policy.
Right.
Okay, if you have your collection policy, you know, and that discussion just may be a Q&A with your manager about, you know, can you look into this? I'm not really sure what KSN has done. That's a discussion. There's nothing to report afterwards. But if you've already given management the authority to follow your collection policy, then you have no real action after.
And that answers your question. What I've been doing, spending a lot of my time when I'm not on the phone talking about this case, is drafting policies and resolutions that go along these lines. One of the ways to get around a lot of the teeth in Palm is to delegate authority. So Palm does not stop you from drafting a day-to-day operations policy. And we're going to delegate the authority to do day-to-day operations up to a certain amount of money to the board president. There's nothing in Palm that prohibits you from doing that, as long as you vote on that resolution in an open meeting. And there's absolutely nothing that stops you from doing that. The other policy that I'm drafting a lot of is the collection policy. Now, I know a lot of management contracts already kind of have one tucked in there about we'll turn it over and there's a blank X number of days to, well, you know, from our perspective, we want that to be something that's explicitly voted on in an open meeting about what your policy is. It's a refresher course for owners too, because it's going to be something given out. If they're going to be told this is going forward, this is the collection policy that's going to be followed. And that's going to delegate to your manager if somebody's account is X number of dollars delinquent or X number of days delinquent, then they have the obligation, not the right, to turn it over to collections. That's going to stop any favoritism, any preferential treatment, any issues, because one of the biggest things you hear when you go into court is you're not evenly enforcing this. They can demonstrate somebody who's not been turned over because it's the best friend of the board president. I don't care if, we sue board members, because if they are paying their assessments, they're no different than any other member. You gotta pay.
Yeah, it's public knowledge anyway. A lot of this, you can just go into certain systems, you see that Joe Blow hasn't paid their dues for the last 5 years, this one did. So if you're gonna do it under this Palm method, you don't wanna be a bad person, but you can't bring that person's name up and or address.
Oh yeah, listen, this is all, we live in a technology world, right? I mean, you can find out pretty much anything you wanna find out.
You know, people don't want to say it, but
Right.
unfortunately, it's the way.
No, I agree with that. Sir, did you have a question?
Yes, you can help me, Michael. I'm trying very hard to look at the big picture.
Sure.
And how the whole thing started. Is it one issue or is it a chain reaction that was based on something very fundamental, let's say high tech, or the conditions of the ground have been changing to such an extent, at such a rate, that we cannot really allow this to continue? I have a very hard time to understand this, because sometimes we go through in history, and we look at human nature per se has not changed, technology has changed. There are certain things that repeat themselves. So if I look at, my association, there are certain personalities, certain egos that we expect with almost mathematical precision what they're going to do, if we consider the conditions ABC.
Sure.
So in this case, is it a preventative action by the PALM decision to prevent something that should not happen in the ideal situation?
Well, yeah, the Palm decision, in my opinion, was trying to put people back to what they should have been doing. And again, I didn't say this, but this is probably the single most impactful case that's come down in 15 or 20 years, where there hadn't been this, the appellate court had not weighed in on the way that you guys as board members transact business. They just hadn't. So this was their chance after decades of people kind of going fast and loose in the way they did their business. This is the first time they've really stepped in and said, hey guys, we think the statute says this, and we think this is what they mean. Now, again, this is potentially something that could be legislated around. There's no question that we know that they've already formed committees to discuss, and all they're going to have to do is just clearly define what it means to be conducting business. It's not going to be hard to change the Condo Act to state very clearly that conducting business does not mean discussion. I don't think that's going to be splitting atoms to do something like that. But, and just so you know, another piece of background, 2800 Lakeshore Drive, they did actually petition the Illinois State Supreme Court. So this could actually be overturned by the Illinois State Supreme Court, but I can tell you, they take about 1% of the cases, which means that there's a very small chance. And it wouldn't be until 2015 until we actually got some kind of an opinion from them anyway, even if they took it. So for the short term, we're living with this. This isn't going away anytime soon. Because they're done drafting bills for this year anyway. So them talking about legislation, we're talking about a 2015 fix. Sir?
Can Palm be made retroactive, or is it only going forward from a certain day?
That's a good question. I've been asked it a couple times. There's not a perfect world answer. From your perspective, once you're made aware of something, from my perspective, once I'm aware of something, I have an obligation to try my best to follow it. So if you didn't know something, if you didn't know that it meant to be transacting business by discussing that was volatile, I don't believe that you can be held accountable because it wasn't law then. So it really, from my perspective, would be on a going forward basis. I don't know how they could now say, well, hey, 10 years ago, you guys weren't doing this for the last decade. You didn't know you had to be doing it a certain way. Nobody had pointed it out to you. And really, again, it's a court's interpretation. Remember, they didn't change the law, they just changed their interpretation of what they think it means, which is another reason why we don't think the Illinois State Supreme Court is going to take it. Go ahead, I think you were next. Sorry.
Oh, so I was just wondering then, so they do change, the legislature does change the Illinois Condominium Act to define what this.
It'll change both statutes, but yeah.
Okay, then the court's kind of, the Palm decision is kind of negated then?
Yeah, sure. They legislate around decisions all the time where they say, well, and clearly it's kind of an indication for Gary Palm to be sitting on a committee that's trying to legislate around it that he didn't expect he kind of got an unintended consequence where he wanted to push it, but I don't think he ever thought they would extend it to where they did. So he, in his own mind, I don't think he believes, a couple of my partners know him and serve on committees with him. I don't personally know him. I certainly like to shake him and say, what in the world are you doing? But I don't want to go to jail either. You may have
I want to touch on this collection policy.
Yep.
Should that be passed at an owners meeting or a board meeting?
It would be a board meeting that voted, so it'd be voted on by the board, but it's an open meeting.
Yes, but there's two types of.
Yes, so that's a good distinction. So the Condo Act requires that you have one member meeting a year, which is your annual. It's all you have to have. We all know that you can have more than that because you could have special member meetings called by a petition of 20% of the owners, or by the board president, or by, depending upon your documents, by a chunk of your board members can call for it. But that's usually like a vote to remove a board member. A special meeting to do what, any area, to argue about the budget if they don't like the raise in the budget. There's certain rights that members have to call special member meetings. The statute requires that you have 4 board meetings, a minimum of 4 board meetings a year. Now, I can tell you that another way that people are getting around this, and I don't want to jump around too much, but I am a little bit here. One of the ways that you can get around Palm, in a really novel way that I've heard, all you need to have under the statute is 48 hours notice for a board meeting. There's no backstop For member meetings, it's not more than 30 days, not less than 10 days for your notice. So there's a backstop, there's the 30-day date. Well, I've got boards now sending out notices for their meetings for the entire year. And they're saying, one of the real novel ones that I heard was, we're gonna hold a meeting every Thursday night at 7 o'clock at the pool house. If a quorum of the board does not show up at 7, whatever the time is on Thursday, there won't be a meeting. Well, guess what? You've now just noticed all your meetings for the year, so you've satisfied the notice requirement. And you know what? If there's no business to be transacted, a quorum of the board won't show up. Might it be a little rude because people might come down to the pool house? Yeah, but guess what? You're following Palm by doing that. I mean, you've now complied with the notice provision. The other way that a lot of management companies are trying to get around it with is doing conference lines. And because there's no requirement that the board members be live in person, they just have to be live in a board meeting. So they can be on the phone. So you could have a speaker box sitting right here, and all the board members can call in, and any of the members that want to come and listen have the right to be here and listen.
That's good.
And management companies that have conference rooms, well, they'll just schedule. And the other one is schedule it at noon on a Wednesday. Well, the board members can call in, and they can easily do it. It's their lunch hour. So there's no requirement that it be made super convenient to the members. You have to follow what your declaration says. Some declarations will say that it has to be held in like the county of the association. As long as you follow what it says, there's no issues. I'm sorry, sir. I think you were back.
Thanks. This is such a sensitive issue, and we all have, I mean, it touches us so directly that we could ask you questions all night. I think we all want to do our jobs efficiently, and we want to do our jobs transparently as much as possible. Can you please convey your information and let us ask you questions at the end so we actually get to hear what you want to say tonight?
I would, and as you say that, she raises her hand.
I just want a clarification of the notice clause.
Okay.
We use a website and we put our meetings in a calendar on that website.
Yep.
Is that, in this day and age?
Well, it's
I
not,
think
it matters what your
that's
governing documents say. Because I can tell you one of the things that in the Palm Court, in the Palm case that they did wrong, is that they were just going down to their lobby and they were just posting their meetings. And their governing documents explicitly said that they could post, but that they also had to either hand deliver or mail. So the answer is either change your governing documents or follow your governing documents. And I would say that about any topic. If you don't like it, change it. If it's there, you gotta follow it. So that's one of the things that they said they breached their fiduciary duty on. Did you have one more thing before we? Yeah.
What is there a statute of limitations on fraud?
Yeah.
Now, I know it's 7 years,
Yes.
it's normal, but fraud could be anything, I understand that too. But is there a statute, in other words, if you find out something happened, but it's 15 years later, you still.
So you're asking whether or not it tolls because when it's been discovered?
Maybe, right, after, say it wasn't discovered until 12 years after, but then there was a case because of.
I mean, I know as it relates to construction, there is a statute of repose, but as it relates to fraud, whether or not it's known, I mean, this is a whole separate topic we're going down right now.
Yeah, okay, well, all I'm asking then is, what would be the statute limitation?
On a breach of fiduciary duty claim?
Call it that?
Well, because if I was gonna sue you for breach of fiduciary duty, the second count would be for constructive fraud, so I understand where you're going. Because that's usually the 2 counts that are in a breach of fiduciary duty claim. Now, it's a type of fraud, and I can tell you right now, I haven't litigated in several years, but my understanding is the fraud statute of limitations is, as you said, 7 years. So, unless there's something that monumental has changed, 7 years is the answer.
Okay.
And I don't believe there's a toll, you can't it's not based on when they learned it. Okay, so kind of moving on and moving in. So the major topic about meetings, ways around it. They just talked about when a quorum is present. They don't talk about if you want to do any business or discuss things when you have less than a quorum. Well, one of the explanations is if if the board wants to assign the 2 of you to be your landscaping committee, and they want you guys are going to discuss information and bring it back to the board for the board then to vote on, that doesn't violate Palm. Nobody has a problem with less than a quorum of the board doing those things, going out and collecting information. Nothing in Palm has a problem, and we already touched on this, with delegating things to other people. Palm, and I actually, it's kind of a Freudian slip. I said a committee. Well, everybody in this room probably doesn't know the difference between a commission and a committee. And there actually is a very important distinction, because a committee, these are actual legal terms, or terms of art. A committee actually has the power to bind an association. So if you have a committee, a good example is in an HOA, almost all HOAs have an architectural review committee, an ARC. And they have power to bind. They have the power to actually make decisions over and above the board, whether or not to approve an alteration to a building, whether or not to approve a shed, whether or not, so what you need to understand is that their declaration explicitly created that committee though. And what Palm said is if your declaration doesn't explicitly allow you the right to create a committee, you don't have the right to create a committee. You have the right to create a commission. And a commission is very similar to what we all believe a committee probably was, is that you can form a group of people, as long as it doesn't have a quorum of the board, because now you just turn that commission into a board meeting, you have the right to have them go out, collect all the information on a commission, and bring that information back to the board of directors, because you're volunteers, by the way, remember? And it would be nice to have some other people out there doing some things for you. The normal format is one board member serves on a commission, and they are the head of the commission, they're the chair, and then they collect the information and bring that information back to the board. And I can tell you that Palm does not have any problem whatsoever with that. What Palm has a problem with, or what's going to be the problem that I see, is that I deal with a lot of boards that don't trust each other, and they don't trust their manager. Well, guess what? If you serve on one of those boards, I feel bad for you, because it's going to require you to hold a lot of meetings. Because if you're not willing to delegate information to other groups by a resolution, if you're not willing to delegate certain things to your manager, you're going to have to meet. Under Palm, you're going to have to get together. If you are unwilling to have resolutions that delegate authority, like I said, the day-to-day operations. Well, the board president has the right to one of the things, I drafted 3 of them today. Resolution to grant, for the year of 2014, to grant the day-to-day activities for normal and budgeted for items up to an X amount of money. That would be emergency situations. It's just the day-to-day activities. You're granting that authority to the board president. And then he comes to the next meeting and he reports what, at the very next meeting, he would report what actions he took based on that grant of authority. Palm doesn't have a problem with that. So if boards need to be able to trust, we need to get back to letting our professional managers manage, which I think we've got away from. Board members, and I'm glad everybody's here because it's good for you guys to learn, but board members have to be able to trust as best they can each other and trust their management. Otherwise, under Palm, it's going to be an uphill battle. It's going to result in a number of people not wanting to serve on boards. I get that. You guys are volunteers. The end results are going to be raised directors and officers insurance premiums. They're going to have to raise their rates if you tell them to come to more meetings. They can't, they don't, contrary to belief, they're not, they are for profit just like we are. We're trying to make money. Those are some of the unintended consequences. I foresee if this lasts for a couple of years, you're going to start seeing board members getting paid. Because you're going to have to just amend your governing documents. If nobody wants to serve on the board, what would you serve on the board for $200? Would you serve on the board for $300? I mean, eventually that could happen. And those are the unintended consequences that come out of it. So again, one of the big things that came out of Palm that's not related to that one particular topic was they weren't listening or they weren't soliciting advice from their attorneys. A number of different places where they were told they were breaching their fiduciary duty because they never asked their lawyers. They never solicited an opinion. And had they just asked the question to their lawyers, they would have had an absolute defense because they would have relied on their counsel. And there's case law in Illinois that explicitly says that if you rely on the advice of your attorneys, even if your lawyer's wrong, which sometimes we're wrong, we try not to be, but sometimes we are. Again, that's why I have malpractice insurance. You relying on our advice is an absolute defense to a breach of fiduciary duty claim. They didn't do it. So that's another big thing that came out of Palm. Some of the other things, again, were just follow your governing documents. Some of the things they weren't doing, the notice provision. Additionally, everybody here, after I get done saying this, should go look at their declaration. But there are a good number of declarations in Illinois that at the end of your fiscal year, if you have excess operating funds, you have an obligation to return that to the owners. as a credit, or without it, that's only if your declaration says it. And I know there are a handful, we probably have seen several hundred out of the several thousand we represent that say that. Well, it shouldn't be a big shocker that you have to follow your governing documents. It never should have shocked anybody that the court said, hey guys, do you know that your declaration says this? But I can tell you that the industry, almost across the board, has looked the other way on that and just said, hey, here's an IRS form at the annual election. Just sign it, everybody let's vote on this IRS form, and we'll just roll the money over into your reserve fund. Well, guess what? You can't do that if your declaration doesn't allow it. But again, there's fancy ways around that too. The most novel one I heard from one of my partners, Bob Nesbitt, said, well, why don't we just special assess everybody the exact same amount that you were going to refund them? The same letter will tell them, hey, you get a refund. And by the way, the next paragraph, by the way, we're special assessing you the exact same amount. You could do it. There's nothing that stops you from doing it. So there are novel ways around all these things.
They're liable to think you're doing
Hey, you know what? Yes, I probably am. And so the other things that was that you have to follow the statute. They were doing a number of things that were contrary to the statute. The way they were handling their reserve account and their operating funds, they were commingling those two different accounts. And they were contrary to what a normal person would think. They were reaching into their operating fund during a year, and they were taking money, excess money out of their operating fund, and they were paying back a debt, an obligation in their reserve account. And normally you would think that's counterintuitive to me. I would think that you'd have a shortfall in your operating and you'd grab your reserves to fund your shortfall. That's what the obvious example would be. So this applies to both of those, though, is that the court said you can't use these interchangeably. Your reserve account is earmarked for capital improvements in major projects on the common element, common area, whatever it may be. That's earmarked for that, and your declaration tells you what that's for. You can find that provision that tells you this is what your reserves are for. You don't have the right to just reach in and take that money out, even if you're going to repay it, sir.
Yeah, quick question here. We keep talking the word fiduciary.
Yep.
Okay. But from your law firm, I have received an oath of office.
Yep.
Okay. Now, with this Palm, do you have to take an oath of office?
No. Let me tell you.
Then let me ask you this question. I'm going to answer that. My belief is if you're dealing with people's money, are they going to trust Bob over your meat? I mean, if you're dealing.
Well, they elected you, so.
What?
They elected you, and if they don't like what you do.
So you really don't. The oath of office does not have to be followed.
Let me tell you this. The oath of office was something that Jordan Schifrin created about 14 years ago. It's not a legal binding document. It's in your member handbook, by the way. Every one of you guys got the condo member handbook. At the back of it, there's an oath of office. It's something that, it's a guideline for board members to follow. It's not a binding document. There's nothing about that document. He created it. He probably was sitting on his back porch drinking beers when he created it. There's nothing about that document that's a binding contract. It's a guideline for board members to try to follow. It kind of tells you what your fiduciary duties are, your obligations are.
Right, and I understand that. I just don't.
I equate more to a Boy Scout oath, okay? You're not gonna go to jail. We're not following it, but as Michael said, it's a good roadmap, helps boards work together. You sort of look at, what am I really focused on? Am I focused on me, or am I focused on the association?
Yeah,
I know we're gonna start running late without questions, and I just didn't know if we need to, hit one more of the highlights.
Here's the takeaway, okay? There is no one-size-fits-all answer, because it matters what type of board you have. Do you guys allow each other to, do you trust each other? Do you not trust each other? Do you trust your manager? Are you willing to delegate? Are you not willing to delegate? What do your governing documents say? I've been doing a lot of essentially home audits of people's governing documents, where I'm going through and saying, hey, by the way, are you aware of these provisions? Because these are provisions you likely are not following. It's going to, I hate to say this, it's going to require you to lean more on your attorneys and your managers. Managers are going to be responsible for more and more for foresight, for planning, to make sure that contracts don't become emergencies. How hard is it to know that, hey, these contracts are coming due, we need to do this in a meeting? There aren't many things that if you do the resolutions the way we've discussed, doing a day-to-day resolution, that things have to be effective. It just requires you to be willing to delegate that authority to somebody. If not, 48 hours notice is what it takes for you to call a meeting. That's really not that hard to do. But in our industry, we talked about the days of the 1 minute or the micro meetings are upon us, right? You're going to show up, you're going to say, call a meeting to order, vote on something. Meeting adjourned. Good night, everybody. and you're gonna walk out, and that'll be it. And you're gonna have to do that, and you're gonna have to have meeting minutes if you can't trust each other. The micro meeting, the day is upon us, right?
Well, there's always a reason for it though, too.
Well, yeah, there's gotta be,
If you lose trust, they have to begin with that.
that's true in everything, it's true in marriages.
Yeah, so giving notice is really fairly easy, okay, and it's really down to your governing documents, but if you think about a postcard, and we all set up workshops for next Saturday and so forth, right? We've got time. We should make sure we get those issues consolidated, right? Know what we're gonna talk about, that's what your manager needs to do. But you know what, it's a postcard, board meeting, next Saturday, 9 o'clock, Panera's, okay? If they wanna show up, they can show up. They don't participate, right? You don't have to provide them seats. You've given them a venue that you're gonna be at, and you're gonna just have a workshop.
And
Okay?
working with your
It's different,
man-
but it's not jumping off the ledge.
Working with your manager, and hopefully you have a good professional manager that can help you through these things, and working with your attorney, this is manageable. This isn't the end of the world. What this is a change, and we all really hate change. This happens to be a negative change for most people, but guess what? Changes are coming no matter whether you like it or not, and this happens to be one that we're dealing with right now. So you just have to be willing. I promise you, a year from now, there will be a new hot thing, and we'll be having a conference about a new topic.
Another one, and I hear it from other, friends that, a couple of them are board members, presidents of boards and all this other stuff. There are not a lot, but several boards that are being sued, and the people are winning because of malpractice, whatever you want to call it. And with this Palm situation, I think it's sort of a good idea, because I think you said it also brings out some of the real major problems and brings out forth so everyone could hear it.
Great point. One comment that comes out of that is, one of the comments that I hear, because I go into meetings and everybody's upset, and they talk about transparency. There's no transparency. We don't know what the board's doing. Well, Palm, if you're going to follow it, you aren't going to hear that comment anymore. And you're not going to hear the comment that, hey, I think that contractor's in somebody's pocket.
Right.
That guy's getting a kickback. Well, hey, guy, did you show up to the meeting where we discussed it in front of all of you? Because now you've done it transparently, and all the discussions were out in front of everybody. So you do avoid some of the pitfalls that we've all been facing for years, claiming that we're not being transparent, which is, I hear that, that word is used too much. Sorry.
Responsibility of the property manager. What are if they see something that's not right with the board, is it their responsibility to tell the board that it's, you're on the wrong track, or
good
is
question.
there any legal responsibility if I say the property manager told me to do it this way, and we violate
so he's not an attorney,
How far is that from?
and I can tell you right now that he's got a manager licensing act. Whether or not you guys know that, he's got a new statute that governs what he does, and one of the cardinal things it says is he can't practice law. So he's likely going to punt most of those questions to me,
Okay.
because but I have to actually be asked the question. I can tell you right now, I don't have handcuffs and I'm not going to arm wrestle anybody. I'm going to tell you that I think you're violating Palm, and I'm going to CYA myself. I'm going to put it in a nice piece of paper, and I'm going to tuck it in my file. Because I can't make you follow these things. I can't make you do really anything. All I can do is tell you what I believe the law says, and that I think what you're doing is violating Palm, and he can do the same thing if he says, hey guys, I think what you're doing, this needs to be done a different way. And somebody from a management company asked me that same question. Where does our duty end? Our duty ends once we tell you what we think you should be doing. If you don't choose to take that advice, I can sleep at night because I've done what I needed to do. Again, I don't have handcuffs or a badge or anything. I can't make you comply with Palm. I can just tell you I think you're making a mistake by not. Yes, ma'am.
Sometimes our board president will do an email to the board members just with kind of an update on certain things maybe that we discussed. If we don't reply back, can we just?
There's nothing wrong with the dissemination of information. So if somebody just sends out and says, hey, here's some information, the problem under Palm would be the reply all, somebody responding to that and saying, yeah, number B, I hate that guy, or whatever. That's where you get into trouble, is by the response to it.
So no one should respond.
Correct, or you can respond directly to the person. There's nothing wrong with you having a one-on-one conversation by email, by phone, by any means.
But conducting the vote, which is what we've all done over the internet, right, is what Palm says.
They term it email canvassing. It's canvassing for votes with the other board members. Hey,
Discussing.
that's where you are going to be running afoul of Palm.
all talking about emailing them, and in our situation, we get together and discuss. We have,
Invite, if it's something that cannot be tucked into one of those three categories, by the way, I don't think we got to the final category. I'm glad we got there. The final category is the hiring and firing of employees. Thank you. The hiring and firing of employees is a really big one, by the way, because employees can be extended to contractors. I'm a contractor. Paul's a contractor. So your discussions about the hiring and firing, the retention or termination of contractors is executive session. So I told you about litigation, violations, and retention or firing of contractors or employees. Those are the three categories that are executive session material. That third category is a large, vast number of the things that we face. Where you're talking about landscaping proposals. If that's a retention of a landscaper, I can tuck that nice and neatly into executive session. So I don't have a problem with the discussion. Now again, the vote to retain landscaper A still has to happen in an open meeting. But if it's to discuss whether or not to hire them, that falls into the category of executive session. So that covers a lot of the things that us as board members deal with.
You know, and we, just to clarify that, because it goes back to the procurement piece, right? So I mentioned earlier that when you get down to your 2 or 3 vendors that you want to interview, you know, before I would just say, let's do that, I will send your attorney the question that says they're going to interview vendors, right?
Yep.
It's a discussion. They're not going to vote on one. Does that satisfy? These are the type of things that we have to ask more often in order to make sure we're doing our job. I believe that's okay, but you can't vote on it.
well, what we do, what we have done, since we have a
Being
five-person board.
recorded.
We're all friends here, though.
Yeah, there are 4 brand-new members.
Right.
Well, the person who's been on the longest is not gonna let them stumble around. So we're meeting, and if you have like 3 or 4 contracts, okay? Well, we look at the contracts, so this guy's got a question, that guy's got a question, that guy. Well, if we wait until a board meeting to ask questions, we're not taking a vote on anything.
Right.
We'd be at the meetings for 3 or 4 hours.
Yeah,
It's
we already talked about that.
ridiculous.
We're talking about that could be something done in executive session. It's talking about
When
the
does
retention.
executive session take place? Does it have to be that night of the board meeting?
You would, if you have no business that's being transacted, what you would do is you would notice that there's going to be a meeting, but there is no business other than executive session. So there's not gonna be an open part of the meeting.
Well, there's always something to discuss.
We need to come up with, yeah, we need to come up with rules.
in a workshop and then bring it to the
Well, that's what-
The workshop is what Paul says you're violating.
Well, that's what we're saying, but if we don't do that, if we don't leave this all, you know, open to our board for them to throw questions out, then you bring all these vendors into your meeting, one after the other, for everybody to ask them
Then
the
the
questions.
answer, Paul, is that less than a quorum of your board can field those questions and deal with those vendors. Under Palm, less than a quorum of the board has the right to do that. They can do it any day, any hour of the night, they can do it all night long. It's when you get a quorum of your board together and do that, under Palm, that you will start running into the issue. And again, every situation is slightly different, and it's gonna keep us attorneys busy, but those are the types of questions that you're gonna have to ask to protect yourself. Because if I give you an answer and you follow it, you're covered. You're not reaching for your shoe. Go ahead.
I just want to ask about this, to get away from a normal board meeting. We call it a workshop. We invite everybody to come and observe what we're doing as we go through the contracts.
You're doing the right thing under Paul.
And we're advertising.
And you're calling it a workshop, but it's not a workshop, it's a board meeting. I mean, you're technically.
But we're not making a decision right then and there because we just had an opportunity. Maybe we have questions that we want the property manager to go back on and.
It's gonna be a while before this happens, but I assure you, the more you do these things and you're sitting and discussing and no business is being transacted, people aren't gonna come. I mean, they're just not
Our workshops, they don't come.
They're not gonna show up. I mean, I know it sounds like a hassle to have to notice it, and it is. And one of the final things that I urge you guys to do is the statutes allow you guys to give notice to people by another means, so by email, as long as the person explicitly, in writing, accepts that as a new mode of service. So my theory is that every time you have a meeting, you should put at one of the tables a notepad that says, if you put down your name and your email address, you agree to have your notice be sent to you by email. You will be responsible for any changes in email. So now it's not your burden if the email address goes bad. They have the burden to update you on a new email address. and get a running list. It's gonna make their job easier to send out notices, and it's gonna make, you guys are gonna save money because you're not gonna run up postage bills and paper bills. That's how I think that the industry needs to
People
start.
who don't have computers.
They don't, then you're gonna send it the regular way.
And
That's
just
the way you do
back-
it now, so.
And just back to that comment, you did have, that is a board meeting, and you could vote.
You could have.
We
voted.
could have, but we decided,
But because you gave proper notice. So
Right.
what changes in your world is that they're really board meetings and you have to keep minutes. That's
Yeah.
what- If you make a decision, you have to keep minutes.
well, we don't make decisions
But
during
Then you
the
don't have an
workshop.
obligation.
We just go, we
Yeah.
discuss.
I know.
Yes, sir?
For it to be a meeting, do you have to enable community members to be physically present, or just have it be something that they are privy to everything that's going on? For example, a web meeting where they can log on, where they can log on to the meeting and have the log-on information.
Technically, right now, the statute has written, and we could talk a while longer on this, but we're not going to. There is a bill right now that's being voted on, that's right now could become law tomorrow, that deals with enhancing notices and voting electronically. So there is a bill that tomorrow I could be talking to you about a whole new set of rules that the governor is gonna sign. But as we sit here right now, there needs to be a date, time, and place, and purpose of a meeting. You need to have, if there's an agenda of what you're gonna do. So the place thing makes me nervous to say that they don't have an actual location to show up to.
Okay.
So I know what you're saying about having a chat room, basically. Some management companies are saying, well, let's just do the conference line, but we'll make an open one line, will just be for all the owners to call in on and just listen. Nobody's weighed in on that yet. But I'm nervous to hear you not have an actual place, which is why I've always said, well, just have a place where the members can show up and listen. I don't know what a judge is gonna say about there not technically being a place for the meeting.
Yeah, there will be more board meetings, but it'll also help with the discipline that when you have these, what used to be workshops that are now going to become board meetings, right? You really have to have firm rules about participation. It is strictly for them to listen.
So we can
Okay.
post that, like, if we post, there will be no open forum on our notice.
Absolutely.
So that would be okay to do?
Sure.
Absolutely.
Now, if you have to be willing to do something with that information. I've been to your meetings, and those people are certainly not gonna listen to a sign. They don't listen to me, so I don't know if they're gonna listen to a sign.
I don't think I want to give in your.
I want to get back to this one question on fiduciary responsibility
Sure.
and talking about the budget and using your reserve fund and your operating fund.
Sure.
What, does that mean when you need to accrue in your reserve for anticipated expenses for the reserve and then pay out of the reserve?
Correct.
Or can you,
But your declaration usually will say, I just looked at this exact question this morning. This declaration said that they must use their reserves before they use what other means, such as borrowing money, or, so they had in that association, they had an obligation to use their reserves first before they could borrow money.
if it was for capital?
Correct.
Okay,
Replacing the roofs.
right.
I should have introduced our CFO, Don Franzese, here, and when we talk about the few communities that require, we have 3 communities that require excess funds to be paid. We have 3, but one is maybe, okay, another one says must be, and I forget what the third one is, right? All 3 have 3 different solutions, and Don used to have a full head of hair before Palm came out.
No, it's tough, and right now, we're still trying to digest what it means, because again, depending on what the wording is, we have 5 solutions to resolve that, right? So we're working through each of those associations to try to figure out the best way to do it.
And that involves the attorney, and it involves your auditor, and it involves Don, and it involves me, and your property manager, so, but.
That's no one size fits all answer, and that's why some people come to me and say, just tell me how to get around home. Well, I got a lot of questions for you then. Because it matters what
No
you're.
one's even figured out how to undo the commingling issue, because the minute an assessment payment comes in, we're commingling funds. So, and we're not gonna be able to undo that today.
Are you commingling or are you dispersing you're dispersing
No,
after you
well,
receive
the pure definition says we're commingling funds. The minute I say accept a check that for reserve payment and operating assessment, it's commingling funds.
You commingled it,
Yeah,
when you wrote it as a
somebody
homeowner.
commingled it.
Right, in a perfect world, you write 2 checks.
Right.
And who wants to do that?
Nobody's gonna do
We have
that.
2 checking accounts, well, that's not gonna happen today.
But you're dealing in a utopian situation where you have to understand, there's no damages in what you're doing. So you have to try to follow all the best you
Keeping
can.
good records
Yes.
of what we're doing, okay, saying we're gonna move some funds, to pay for a reserve item and being a little bit more diligent about moving that 30,000 exactly, showing that we've moved it and making the payment out of the operating account.
I can tell you, if we every day work 1,000 hours to be perfect at POM, Michael said it before, 6 months from now, we'll still be trying to figure it out.
Right.
But the message is, go back to the very simple part. What does the Condo Act say? We really need to make sure we're following that, okay? What does your declaration say? We need to follow that. That's regardless of POM, and that really should be. But when we talk about delegating responsibilities, I think that's where the boards really need to make that decision, and some people on the board really do need to kind of decide, and it's something you can change every month. But, I would like to recommend to one of our boards, particularly with an issue of that, is appoint the 2 people to make decisions on the day-to-day business between board meetings. And you gotta have some trust. And you know what, in 30 days, maybe you wanna change who those 2 people are, right? But you have an opportunity to keep business going. And it doesn't mean that they can't go and tell you what decision they made before the board meeting. You just can't all meet and decide on it. So it is different. I think what's really different is we envision extra board meetings being like our board meetings, okay? 2 hours, right? If anyone's more than 2 hours, 3 hours, right? You're gonna have workshops and you're gonna have some extra meetings, but they need to be 20 minutes. They need to be an hour.
And you gotta learn how to do it without your manager. Because frankly, if there's limited purposes, and he's not gonna go to 30 meetings for one association in a year. So the answer is, you're gonna have to learn how to call a meeting to order, to vote on certain things, and to adjourn a meeting. Simple, procedures that we usually rely on our managers for, that frankly, you're gonna have to, or you're never gonna be able to afford it a manager. That's just, the reality is that if it's a micro meeting, a 1-minute meeting, he doesn't need to drive out to your location to help you through that.
I think after this, nobody's gonna wanna be on a board, and that's gonna be it.
That's
That's
certainly
one of the big punchlines of this whole thing, and that's what we're going to help guard against.
What are requirements of notice? I mean, can you just put it up in one spot? Or
Depends what your declaration says. In Paul, it said very clearly they had to post and either hand deliver or mail. And they weren't doing the hand deliver or mail part about it. They were just posting, so they violated their governing documents. So you gotta look at what your notice provision is.
Your declaration decides that, and I promise you, it's absolutely not one size fits all.
Michael, we spoke about declarations a lot here. We had ours revised 8 years ago.
Yep.
You haven't looked at it again?
Certainly if what you hear back or you look at it and you say, we have concerns about this, about how we're, yes, the answer, 8 years is not that old, by the way.
Yeah.
If we're seeing 15, 15 or 20 years old, yeah, you probably got a number of things there that violate the statute already. Because over 15 years, there's been a lot of amendments that change, and you're handing out a document that's inherently wrong. So yeah, the answer is that 8 years, no, I don't know that that will change. I got to my punchline. There is no punchline. The punchline is that, unfortunately, that board members, you have some more obligations on you. I promise in 6 months, once you let this wash over you, you're going to hopefully take a couple of deep breaths and the panic will wash off. I really don't think it is as end all as a lot of people are believing. It's just a big change because we've all been doing it somewhat flawed. And we just have to come back to the way it was. And as new board members come onto boards who learn to do it the way Paul wants it, you're going to slowly start to see it just be transacted that way. Trust your professional managers. Trust advice of the people that you hire to make, to give you these things, to give you this information, and it's going to be a lot easier. It really will.
I know several people are restless and moving out the door, so, you know, I'm just gonna suggest, Michael, that, you know, we'll wrap up, but, you know, Michael and I'll be here, for, if you wanna come up in small groups or ask some questions.
Or take my card and email me.
Yes, and I have some cards, if you'd like to send me an email, if anybody wants a card, be happy to.
Well, I've got a pile of cards up here at the front.
Yeah, I only have 12.